distinguished panel, friends and colleagues, are there any questions from the audience about this bill or the topic more generally? Have we exhausted you? Professor Matheson.
Well, I have a question, but I'd like to press with a comment. This has really been an amazing presentation, and it tells an incredible story, starting with the way you and Heather got inspired about an issue in a seminar in the law school, and taking it step by step, and coming together, and the legislative PhD's office. It's an amazing story. I just want to compliment all of you for the hard work that you've done on this, and I just think you ought to acknowledge that.
The ending to the story by lobbying your legislative representatives to vote in favor.
Well, it is an ongoing story, but I actually have a question, and maybe it's a little bit of a technical question, and it starts with Professor Anderson. Your overview of the various steps along the way where convictions can be challenged, whether it's post-trial, appellate review, trial attack, post-conviction remedies, and that sort of thing. I thought was an excellent descriptive overview. But I couldn't help but thinking, as I was listening to you talk about the various standards of review, whether there was some normative viewpoint involved in that as well. And in light of the experience with the Innocence Project, both here and nationally, and what we've seen and experienced over the years in terms of exonerations, I'm wondering if you and really other members of the panel think there should be some rethinking about some of the standards of review that you were talking about, because after all, there is a reason that they're tough standards. But was that mostly just a descriptive overview, or are there some things that you think really ought to be changed at that level?
You know, I won't sit here and pretend that I don't approach it from an innocence point of view. I mean, and also, before I approached it from an innocence point of view, I certainly approached it from a defense attorney point of view. So, I mean, I certainly approach it with a certain bias, and I admit that. I mean, I do understand to a certain extent, and probably to a great extent, the reasons why the standards are so strict. I mean, there has to be some integrity and finality in our system. And I don't sit here claiming that by any means that I think most of the people who are incarcerated in our prisons are innocent, or that, I mean, I think Aaron's point that, you know, only a certain number of people have come under the statute over the years isn't somewhat indicative. I mean, some of it's because the smallest, there's a tiny little organization that's doing an investigation, and Aaron doesn't even know what's coming the way it's doing it. But, I mean, I do think that I guess I'm going to answer your question. I would say to you, I think this legislation goes a long way in making me feel less upset about the standards that are out there. I mean, this new statute allows a person without DNA evidence to get back into court under certain standards. It sets up a process that I think is fair, that I think recognizes that there are people who will try to abuse the system. And so I think a statute like this goes a long way in fixing that, in making me feel less sort of annoyed by the standards of proof that are out there. That said, I think it's really dangerous as you know, we get tough on time, that we start to chip away at habeas rights, or that we limit times, or we try to make the system go more quickly. I mean, I think if we, you know, particularly federally, try to tighten those standards or make them even more strict than they are, I think we're really doing a disservice to the system. I mean, these exonerations, both DNA and non-DNA exonerations, have shown that our system's not perfect, that innocent people are getting convicted, and that we need to provide remedies within our system for those folks. Now, that's not to say that within the system, people who are guilty are going to try to take advantage of those processes, but perhaps it comes down for me to that, you know, rather to let 9 guilty people go than to keep one innocent one in prison. So I think we need to be very careful about considering any kind of tightening of those standards. And I guess in Utah with this new statute, I'm not sure I feel as concerned about loosening them. So I guess, but I also come at it from a very biased point of view.
May I just, there was some discussion earlier about the possibility that we could quantify the number of people in prison, and there actually are some numbers that can be used, and frankly those numbers are startling. If you apply just a 1% error rate to the criminal justice system, that's an error rate that would be applied to any human endeavor, any project, any government activity. You're talking about a substantial number of people in prison. We have 2.2 million people in prison in America, and with a 1% error rate, which we certainly have, that's a substantial number. But some states, including the state of Virginia, from where I come, have been able to quantify it at a much greater number. In Virginia, Governor Warner ordered an audit of criminal cases coming out of the crime lab because there have been a number of exonerations that had resulted from a particular forensic scientist there. And through a random audit of the cases just coming out of the crime lab, rapes and murders, Virginia discovered that it had a 6% error rate in its criminal justice system, so that 6% of the people that it was sending to prison were innocent. There is a forthcoming article that took a very, very conservative examination of, or a conservative approach to quantifying these numbers, and has very credibly and compellingly put the number at 3 to 5%. These are substantial numbers, and it's not just an impact on the innocent defendant or the family of the defendant. The crime victim has no closure and no justice when these mistakes are made. So the criminal, it's not just the integrity of the criminal justice system and the public's faith in that system, but we actually haven't done the job. We've done a disservice to the crime victim. And so this is a very important issue, and I just want to say also, and finally, that the best way to these cases is for these cases to have been done properly to begin. There are some very practical and frankly affordable and sustainable reforms that can be applied during the investigation part of these cases to prevent the person, or the innocent person, from being falsely accused in the first place. And that really is what we all want. But until those reforms or those practices are put into place, we have to have these post-conviction remedies like the habeas corpus or the setting aside of the verdict available to the innocent person to make sure that the mistake is corrected.
And I think probably where I come from on this too is that the part of those statutes that worries me probably the most are the time limits.
Yes.
Virginia has a 21-day rule.
It's been extended to 90 now. It's 90 days now.
90 days for newly discovered evidence, and that's it. So, those are probably the place where I would say I try to be less biased self and more objective, and yet I still really have some problems with this time limits.
Great.
Yeah, picking up on something that Katie said, having to do with sort of looking at all the different things that could be done in this area. We all recognize that this is one aspect of it, but as we were looking at this, we thought, we need to do what we can, police and prosecutors, to the kinds of things, the kind of mistakes that can lead to wrongful convictions. And so as part of the effort this past year, I mentioned Scott Hornoff coming out to address the legislature. We also had him go, and we did a joint presentation before the Utah Peace Officers Association to try and start educating the police about this and about what lessons we can learn from these cases where people like Scott Hornoff get convicted of crimes that they didn't commit. There are, as Katie said, there are certain things like eyewitness identification procedures and taping of confessions and a number of things, bad science, and the use of snitches in criminal cases where there's not decent corroboration. A lot of these things are really important to get the word to the police and the prosecutors. And so besides the police training, we also in September had the major prosecutor training of the year, Utah Prosecution Council Fall Conference, and we brought out Kirk Bloodsworth, who was the first exoneree from death row in the United States, back in Maryland. And Kirk came out and addressed the prosecutors' convention, and we also did a presentation and a panel discussion with some prosecutors talking about the lessons that could be learned from cases like Kirk's, with people who are demonstrably innocent, who's convicted. In fact, he was convicted twice, first time death row, second time life without parole, and eventually exonerated after through DNA evidence and the actual perpetrator was found. And so I think that educational part of it is crucial as well, and then we're working to get that word out. And by the way, that presentation was very well received by the prosecutors. When I first brought that up in the training committee, there was some, well, you know, these innocence projects, they claim all these people are innocent that aren't. I said, you know, if one of them is innocent and demonstrably innocent, that's a concern to all of us, because, you know, it's an important part of the prosecutor's job to make sure that we don't convict the innocent as it is to convict the guilty. And we need to not get into that debate as to whether or not they're, you know, 500 or 200 or 300, and just say, you know, we know it does happen. And let's see what we can do to make sure that we do everything we can not to make it happen. So as I say, initially there was a little bit of reluctance, and they said, okay, let's not just do it, but let's make it the first thing that we do with the kickoff presentation. We'll do a 2-hour thing. You bring somebody in. We brought in Kirk, and it was one of the highest rated presentations that we'd ever done. I think it was impactful for prosecutors to think about that.
Thanks, Craig. Any other questions? Yes, in the back.
I was unclear on whether this bill provides for attorney's fees, investigative costs, and court costs.
No, it doesn't. What it does is it provides a flat amount that they would receive, which is something that would be determined the year that they're exonerated by an objective standard of was that workforce services, the annual wage earner, a single wage earner in Utah, and right now they're around the mid-30s. But for every year that somebody is in, and the first year they get more, and it goes through the Crime Victims Reparations Fund, but then the legislature, the next legislative session, reimburses that fund and sets aside the remainder of that money for CCJJ to administer on an ongoing basis to that individual. So it's a set amount, and we talk about, you know, nobody pretends that this is anywhere near sufficient. And I don't know about anybody else here, but you know, for being in jail 2 days, I wouldn't take that kind of. I mean, you know, the idea that somehow this is really going to make somebody whole is not really true. But these people will come out, as Katie mentioned, and Heather, going through the process, the prospect of another legal proceeding in order to wrangle money from the state, as opposed to even the benefit that the state recognizes them as an innocent person. And part of our bill does some symbolic things in that area too, besides providing for automatic expungement. It provides for the judge to actually provide the innocent person with a letter affirmatively establishing that they have been exonerated. And so as you talk to exonerees, they think this is a good thing, even though they acknowledge that it's nowhere near sufficient to actually compensate. But we also keep attorney's fees out of it for purposes of getting this award, because this doesn't go through any process that requires attorneys. Once you go through the process of exoneration, for example, the Innocence Project represents somebody and there's a determination of factual innocence, they just walk across the street with that and the payment starts flowing, and there's no haggling with attorneys.
Any questions? Comments?
Just two questions that are likely to be softballs, but I'm not familiar with the statute. And the first is, how does the statute draw a bright line between someone that's factually innocent and someone that's gotten off on a technicality? For instance, the person that Aaron talked about, is that person, did they get off on a technicality, or were they found factually innocent? just having it right now.
That is not a softball. We might need to separate James and Aaron.
That's a whole nother debate between Aaron and I.
But that was not a technicality. I would agree. That is not someone who got off on a technicality. That is someone where there's some really troubling evidence. I'm just not totally sure exactly what it means. So, you know, a technicality would be something, some legal issue or procedural flaw. That's not what occurred here. It was related to the evidence. It's just that there's still some issues about what that evidence really means and shows.
And a person like that could still then go and try and establish under this standard. I mean, what it established sufficient for the stipulation was that it undermined the confidence in the outcome, and so we're going to vacate the conviction. The person then could be retried by the local jurisdiction. The local jurisdiction decided not to. But it wouldn't prevent them from saying, you know, I think this evidence goes beyond just undercutting the confidence of the verdict. I think this is enough to establish factual innocence and press the claim. There's nothing precluding that.
Well, then the statute, I mean, I think the setting that side, the case aside, the answer to your question is that the statute requires that the person go through a process by which he or she proves his or her factual innocence on new evidence beyond a clear, with the standard being clear and convincing, beyond a clear and convincing. Sorry, I totally just twisted my tongue. But there is but before you get to the issue of restitution, there's a process that the person has to go through. And that evidence could be DNA, the result of DNA testing, or it could be some other new evidence that wasn't available at the time of his or her trial. And the judge makes a finding, a factual finding of that person is innocent. And then they're available to go on to receive that restitution. So there's a process that the statute creates for that.
Well, and the statute says, I mean, the DNA testing statute is sort of a two-step process. You start by getting the DNA tested. And then once you have the results of that testing, you file a motion to vacate. And the AG's office can either stipulate to that or can ask for a hearing on that. That's the DNA testing statute. If they stipulate, then that person has a finding of factual innocence, and they can go forward and get compensation. If they have a hearing, and ultimately that person's, the innocence is, the judge accepts the innocence by clear and convincing evidence, then again, they still have a finding of innocence. Under the new statute, it would allow a person who doesn't have DNA evidence to then also get that sort of a finding. In the case that we referred to, what we did was we did the DNA testing. When the evidence came back and questioned the validity of the verdict, we had a choice to either file the motion to vacate under the statute and go through the hearing with the AG's office because of their trouble with the possibility that the evidence, with the evidence. Or they agreed to stipulate under the Post-Conviction the Post-Conviction Remedies Act that this was newly discovered evidence and that we could come in under that statute. If we agreed to that, our client was going to be out of prison in 5 days. If we decided to go forward under the DNA testing statute, which we felt we could do, then our client was going to stay in jail until the hearing happened, and then through the appeals process, if one of the two of us were, I mean, whoever won was likely to appeal it. And so our client obviously chose to go in under the Post-Conviction Remedies Act and not get a finding of innocence, just to come out of prison as a free man. The new statute would allow even someone like that to come back in and try to do a finding of factual innocence, to have that hearing now that they're out of prison, and then go forward to look to get the compensation.
Great. Yes. Oh, Clement, did you have a second question? I'm
The
sorry.
second one's probably easier. How is the state now insulated from the dreaded $15 million suit? Are people now stopped from bringing another judicial or legislative action on their behalf, or
Yes.
to ask for more?
Well, not entirely.
Well, not
We don't want them to be. I mean, we've got this clause in there about how it's the satisfaction of sort of a legal obligation, but we want, for example, if you had a case of somebody who's innocent, went to prison, and let's say they got their eye put out or some terrible thing where we would like to not foreclose the possibility of being able to bring a special bill before the legislature, but you know, and this does not preclude that. It would not give them the right, but then, you know, we like to leave some room because there could be some cases where the hardship would just be extreme and it'd be like this amount of money is not going to do near enough to help maintain the person.
Yes.
Is there a copy of the bill on the website for the Rock County Innocence Center or somewhere else where could we actually read it?
We could certainly post it. It's not posted currently.
Would you
can actually get it, yes.
through the legislative website, le.utah.gov. If you just go to the 2007 general session, I can't remember the bill number.
Well, last year the number was, it was House Bill 154, but
Yeah, so,
would it
so
still
you
be
can,
that?
yeah, no, you'll see last year's.
Okay.
And they're in the process right now of all the bills being drafted and will be numbered shortly. So the version for this year, which there was a technical change, but nothing really substantive in the change. So you can see last year's posted on the list.
So you can search for HB 154.
Or just go on the website under Representative Litvak's name
Yes.
and then bring up his bills, look for this bill, and then click on it. You can get it.
Tara?
I'm just wondering, it sounds like if someone had previously been released, that they can have a hearing now to formulate whether or not they're innocent and start receiving compensation. But is there a way of notifying these individuals so that they can know that this is available to them?
The publicity surrounding the legislation, and other than that, I mean, there'll be, I'm sure, stories about it that this is available. We expected more to happen after the 2001 bill went into effect, because there was quite a bit of publicity about that, and the word gets around out of the prison that there's a mechanism. But
The prison grapevine is quite effective. It continues to be effective. Yes, sir.
What part of the process would this expungement take place?
After the finding of factual innocence, then the person would be automatically entitled to an expungement.
Are there any cases going on that are related to sexual abuse?
Are we investigating any?
Are you working on anything on the Innocence Project?
Well, I mean, the Innocence Project itself, I mean, because we're a 501c3, it's a long day, as my YL students can attest. We're limited in the amount of lobbying that we can do, so we mostly do investigation of cases. I, in my capacity as a University of Utah law professor, was involved in this committee and then the lobbying. We're not doing any kind of lobbying with regards to legislation on the sexual abuse of children. We do investigate cases if they meet our criteria. We have very strict criteria on what cases we will investigate. And our criteria is listed on our website.
But there's none of that going on now.
No, we are, I mean, I'm not really at liberty to talk about the detailed facts of the cases that we're investigating. I mean, we're investigating a wide variety of different, I mean, right now we have more than 20 cases in active investigation and probably 80, is that fair to say, who are in a queue waiting for investigation. And in our 3 jurisdictions.
And there's certainly post-conviction petitions pending right now that involve the cases where the defendant was convicted of sexual abuse of a child. But just because those cases are pending, yeah, the Rocky Mountain Innocence Center isn't necessarily involved in those. In fact, they're just involved in a very small portion of the petitions that actually get filed. And just because a petition is filed doesn't mean that it will be granted. The vast majority of them are denied because they're not able to meet the level of proof that's necessary.
Well, in the interest of your own liberty, there is a reception outside. All of the speakers will be kind enough to join us for a little informal Q&A for those of you who have lingering questions. I'd like to resume my thanks, reiterate my thanks for the gang, and also mention that this is just the first course in a smorgasbord of innocence. Tomorrow we'll have the second session of this symposium, featuring some of the cutting-edge scholarly research in this area, including a presentation by George Thomas, who's with us today, a distinguished professor. In fact, his title is Distinguished Scholar at Rutgers University, Newark. George is going to be presenting some of the latest, hippest research on false confessions. A few other folks will be presenting their research as well. So thank you so much for joining us.